Hi, I'm Pam Flores. You're here today for a webinar on how to name a guardian for your kids. Webinar should take about 15 minutes or so. We've got a lot of information to cover, so let's get started. In order to best follow along today, you should be uninterrupted. So if you could please turn off your phone for the next quarter hour, please silence your phone and then give yourself some time to fully understand what's involved in selecting a guardian for your kids. To thank you for showing up today and watching the webinar, if you choose to proceed with planning with Flores Legal Group, I have a gift worth $1,000 for you, and I'll fill you in more on that at the end of the presentation. We all have our why of why we do what we do, and my why is my family, my husband Carlos, and my three furry kids, Dixie, Iris, and Ellie. My goal is to always be sure they're protected should something happen to me. And I'm sure for many of you, your why is your kids. If something happened to you tomorrow, who would you have in place to take care of them? In the short term, who would take care of them for, let's say, 2 to 3 weeks if you were sick? If the worst happened to you, who would raise your kids if you could not? The reality is that in the short term, if you don't have someone lined up to watch your kids, they could end up with the police and then Child Protective Services until someone could be named a guardian. And whether that was hours or days, any period of time is too long to have your kids with protective services. What about the long term? If you don't name someone, a judge who doesn't know you, your kids, or your family will decide who raises your kids. And that's probably the worst outcome you would ever want as a parent. How do you even start the process of naming a guardian? Well, what you do is you make a list of all the possibilities. It can be a process of elimination. Although there may be people who wouldn't be your first choice, what you really have to think of, who would be better than foster care? Because at the end of the day, that's not where you want your kids, and you really have to think of what would be the best alternative. One thing that people always make a mistake about is using emotions when they choose their guardians. And kids can't elicit every emotion that you might have. In naming a guardian, you really have to set your emotions aside and make a list of people who you think would do a good job. And these people might not be your relatives, and that's okay. Sometimes your values align more with friends than your family. The important part is that your kids are with people that you would want. Next, make a list of the values that you hold dear. What are those values? And who else in your world holds those same values that you do? The next mistake that people make is choosing a guardian based on what you think their finances are. Wealth doesn't automatically mean a person will be a better parent to your child. And besides, it's your job as a parent to provide funds to your child through either life insurance or assets that you leave them. The guardian of your child should not be the person who controls the money you leave for your kids. And that's a check and balance system to make sure that the decisions are being made in your child's best interests. So the guardian and the person who makes the money decisions should always be two separate people. So remember, don't consider finances and rank the people on your list and select 3 people, not couples, 3 people who align most with your values. The next mistake people make usually is naming only one guardian. And what if that person can't be a guardian for whatever reason? You always need a backup. The next mistake is naming a couple and not clarifying whether each person could serve alone. What if you named your sister and her spouse, and then your sister passed away or they got divorced? Would you want your sister's spouse raising your child alone? If the answer is no, you should indicate that. The next mistake that people make is they don't make a list of people that they absolutely would not want raising their child. You must specifically exclude people. Otherwise, you leave the chance that that person may be named a guardian. It's called a confidential exclusion letter. And in that letter, you specifically state the reasons why you wouldn't want that person to be a guardian for your kids. There may be knowledge that only you have of a sibling, a cousin, a relative, or a friend, and you never intend to tell anybody, but you certainly wouldn't want them to be a guardian of your child. If you don't exclude them, you run the risk of them being appointed a guardian and having the person that you really wouldn't want raising your child. The next mistake is many people only use their will to name guardians for their kids. And why is that a mistake? Well, the obvious reason is, what if you're not dead? You may just be incapacitated. So you always want a standalone document to express your wishes in case you're incapacitated. You might be sick in the hospital for a couple weeks. You intend to come home and be fine, but who's going to take care of your kids in the interim? And then what if you were to pass away? Does the guardian you select even know where your will is? And is the person selected in your will even how you feel currently as to who you would want the guardian to be? Having a standalone document is more easily updated than always updating your will if you want to change the guardian. The next mistake people make is, in a will, most people name just long-term guardians. What about the short term? I call these people your first responders. These are the ones who could drop everything and get to your kids in 30 minutes or less. This will keep them out of the hands of the police and the protective service system. Your first responders can be neighbors, friends, relatives. Whoever they are in your life, they could even be coworkers. They need to be close by because they need to be able to act fast. After you've decided on who your short-term and your long-term guardians should be, you need to go see a lawyer. Documenting your choices, you do that both in legal estate planning documents as well as what we discussed in standalone documents. Having it documented in both places will avoid costly disputes that your family or your friends would have as to who the actual guardians would be after you're gone or while you're incapacitated. Without them, the judge has nothing to rely on as far as what your decisions would actually be and what you would want. Included with all of my estate plans, I include a comprehensive kids protection plan. We name short-term first responders. They'll get a letter from me giving them authority to have your children. We also name long-term guardians in a standalone document that would be effective in cases of incapacity and in death. I assist you in preparing emergency instructions for both your caregivers and your long-term guardians. I create wallet ID cards for you that would alert the police or protective services of who to call in case of an emergency. This would prevent your kids from being taken into foster care, which would be the case if they didn't know who to call. You put this card in your wallet or even in your glove box, so if something happened to you, the police would look at this card and have the name and phone number of someone that you've already selected that you would be okay with having custody of your children. That gives the police the authority to call those people, and they would already have the letter giving them the authority that they could show the police, thereby preventing your kids from being taken into protective services. The next mistake that people often make is not leaving any documentation for their guardians. As I mentioned before, most people name guardians in their wills, but then they just put the will in a drawer and they forget about it. They never leave the people that they've selected with any sort of information. Some people even don't even tell the guardians that they've selected them of guardians. Your choices need the documentation on hand in order to step in when they're called to do so. This shows the police and or a court that they have the legal right granted by you to care for your kids. Now, although you know that your choice of guardian has the same values as you, what about the other instructions as how you want your kids raised? Do they buy them a new car? Do they make them get a job? Do they send them to private school? Do they pay 100% for their college? These are all instructions that you should be leaving for your guardian just in the case you're not there. And although your guardian would hold the same values as you, they may not have the same financial goals as you do. And by leaving these instructions for them, you sort of give them a roadmap of exactly what you would do in those situations. The last mistake that parents often make is not planning for their assets. What a lot of people don't realize is that when you leave your estate to your kids in a will, they get 100% of it with no strings attached at the age of 18. That's probably not what any parent would want. The same result would happen if you didn't have a will as well. In both instances, your estate would go through the probate court where it could get eaten up by costs and expenses. Probate can be very expensive due to attorney's fees, court costs, and creditors. And probate can take up to 12 to 18 months in Wisconsin. It's a long time for your kids to have to wait for their guardian to access your assets. In Wisconsin, probate costs are about 5% of the estate. Even with a smaller estate, you can see how the costs can add up very quickly. All of that can be avoided by working with me. Traditional lawyers charge by the hour, and you usually just end up with an expensive set of documents that you put in a drawer and forget about. With me, I only charge one flat fee that's agreed to in advance. My plans consider the growth of both your family and your assets. And my kids' protection plan is included in every plan I draft. With my kids' protection plan, we cover all the bases to avoid all the mistakes we just covered in this webinar. We put the plan in place to keep your kids safe and with the people you choose should something happen to you. Cost is always a big concern. If you don't plan, the cost is always going to be way more than if you planned ahead. A typical lawyer in our area charges around $1,000 for a minimal estate plan that leaves too much to chance with your assets and with your kids by only usually naming guardians in a will. When you meet with me, we go over your assets, we discuss your goals, and how you want your kids raised. You select the plan at the price you want. The range of fees for my plans are from about $1,500 to $5,000, and they all include the kids' protection plan, so you can ensure your kids are always safe with the people who love them. My process starts with a careful review of your specific assets, goals, and situation. We have a working meeting called a family wealth planning session. After we've drafted your plan, we schedule your signing meeting. About 4 weeks after your signing, we have our final meeting where I'll deliver your documents to you along with the USB of your documents for safekeeping. We'll also conduct a legacy interview so you can pass more to your kids than just money. This is where you pass along your hopes and dreams for them and also pass along your wisdom. I take a video of you and I ask you questions, and it's a keepsake that they will treasure forever. It's easy to put off estate planning, but it's one of those things that if you do, the result can be catastrophic for your family. Because you're attending today, I'm going to offer you a $1,000 gift. If you schedule a family wealth planning session within 2 weeks of watching this webinar, and you complete the homework that I'm going to send you, there'll be no charge for the family wealth planning session. I usually charge $750 for this meeting as a standalone service. And as an incentive for you to move forward with putting a plan in place for your family, if you decide you want to move forward with planning, you'll also receive $250 off of your plan. You can schedule your family wealth planning session by emailing me at pam@floreslegalgroup.com or by calling me at 262-420-8582. Thank you all for attending today, and I hope you have a great week.